Good morning, everybody. I'd like to start by saying that this is not a fight between the federal courts and the state prison system. This is about the people of California. The federal judges ask us to submit a population reduction plan that would either jeopardize public safety, undermine realignment, or cost taxpayers hundreds of millions of dollars. In order to satisfy the court's order and to avoid contempt of court charges, we have submitted a population reduction plan, but we are doing so under protest. We have respectfully asked the federal courts to vacate or modify their arbitrary 137.5% of original design capacity population cap. This is about more than percentages. This is about the safety of our communities and scarce tax dollars. Since this case was originally filed, the state has transformed the prison healthcare system into one of the best in the nation. We have spent well over $1 billion investing in new healthcare facilities and new treatment space. We have hired hundreds of new doctors, nurses, psychiatrists, and other medical and mental health staff. At the same time, we have dramatically reduced the prison population. There are now over 42,000 fewer inmates in California prisons than there were in 2006. Just in the past year and a half, we have dropped the prison population by more than 25,000 inmates. This is an unprecedented undertaking, something that has not been done before in California and something that has not been done anywhere in this nation. And yet the courts have chosen not to acknowledge these sweeping changes. I testified for the plaintiffs in 2008. I was speaking the truth then when I said that I thought this system was too overcrowded to provide quality care. But that was then and this is now. I am speaking the truth today when I say that this is a different system. This is a system that is delivering quality care, a constitutional level of care. Any further forced reductions in our population is both unnecessary and unsafe. I'm disappointed that the judges have not taken an in-depth look at all we've done. There hasn't been a hearing in this case since 2008. This should be about more than a number. This case is too important to the people of California, to the safety of our neighborhoods. It warrants a fair consideration of the evidence. The court should be looking at whether we are providing quality care, not whether we've met their 137.5% figure. That number is based on an outdated original design capacity, not today's operating capacity. Original design capacity in California assumes one person per cell, and it doesn't take into consideration the treatment space that we've added in our institutions. Not one prison system in the nation, including the Federal Bureau of Prisons, measures capacity in this way. Double celling is the norm throughout the country and is recognized as appropriate by the American Correctional Association, the nation's highly respected prison accreditation organization. I submit to you that if we looked at true operating capacity, we would be well within the court's population cap. But today, we have been ordered to submit a plan to further reduce our population. The plan is ugly. We don't like it. But considering the inmates we have left in our prison population, it's the best plan that we could come up with. Now, let me be clear. There has been some confusion out there in some of the more recent press. We were ordered to do two things. One, we were to list all possible population reduction options. And second, to give them a plan to further reduce our population. We provided a plan which consisted of the best of the bad options that were presented in the first list. The details are laid out in our filing, but essentially it's a three-part plan. All but the expanded fire cap portion of the plan will require legislative approval. The majority of the plan, about 90%, is increasing capacity. We will be doing that by continuing to use out-of-state beds, but only until those inmates who are housed out of state as of June 30th of this year finish their sentences. We will maximize the use of our fire camps. We will contract with county jails for additional beds. And moving forward, we will lease additional secure in-state beds that we will operate. The second part of the plan includes increasing some credits for certain inmates. None of those inmates will be violent offenders. It will not be retroactively applied, and there will be no further realignment, because those inmates that are released under the lower credits will remain on state parole, and if they fail, they will return back to state prison. The third part of the plan involves expanding the criteria for medical parole and creating parole for some elderly inmates. Eligible inmates will go through a thorough review by the Board of Parole Hearings. Again, there will be no effect on the counties, as those offenders will go on state parole, and should they fail, they will return to state prison. This plan is about 2,500 inmates short of the 137.5% mark that the court established for the end of this year. But that is within 2% of what the court ordered. And the plan we present going forward will allow us to meet the court's target by next year. There was simply no way that we could meet the court's number by the end of this year without adding more responsibilities on the counties, jeopardizing realignment, and adversely affecting the public safety. I'm now would like to take some questions.
Mr. Secretary, so that last part is what I was going to make sure that we get clear. It seems as though what the state, the administration is telling the court is two things. Give us the flexibility, that 2,500 number, or be prepared for things that are not in the best interest of the state.
Absolutely. The court has to make the decision, but we believe we've given a plan to them. It's, as I said, it's not a good plan, but it's the best of the worst. And you know, our hope is that that will be suitable for the court and as we move forward.
We're hoping that they'll give you the flexibility on the 137.5.
Absolutely. I can't speak for the court. Excuse me. Yes, sir.
With this plan, including the early release of some prisoners, in the end, should the public be worried about public safety? Should they be worried about an increase in crime, in violence?
Well, first of all, I don't see this as being an early release. An early release is what the plaintiffs want us to do, where you go retroactively and just let people out. In this case, you would be rewarding people a little early for good behavior, or you would be rewarding people somewhat for completing programs. That, in my mind, is not an early release.
But with this plan, in the end, you know, whether it's early release or people getting out, you know, times other than when they would have, are we compromising public safety with this plan?
I think, as we said, we don't like the plan. It's the best thing that we could come up with. One of the reasons to reduce the impact on public safety is to focus on the nonviolent offenders, and that's why there would only be nonviolent offenders as part of the plan. Yes, ma'am.
The things that the court was looking for in this plan is that these changes will last. They will prevent the prisons from becoming overcrowded again. Are you confident that your measures that you're putting forth can do that for the long term?
We believe that the measures that we're putting forward will meet what the court wants, and going forward, we believe that the remedy can be durable, yes.
And even though it seems like most of it's based on construction, that, you know, we're seeing inmates are going to continue to age in our system, and how sustainable is leasing beds and the expense of that?
Well, we plan to get out of leasing the out-of-state beds as soon as we can. I've already said that I think out-of-state is a necessary evil, and it creates a lot of complications. So my plan would be to reduce that as much as we can, and then to try to reduce the reliance on other leased beds as soon as we can as well. As we move to the out years, we do get more benefit from some of the things that are being proposed here.
Mr. Beard, what are some of the things that specifically will need legislative approval?
Everything that is in our plan will need legislative approval, with the exception of the expanded fire camps. because it either requires more money or it requires some change in state law.
Sir, given that you acknowledge that your plan falls short of what the court, in rather strong language in April, asked you to do, are you confident this will allow you to avoid being held in contempt?
I would certainly hope so, and again, I can't speak for the court. Look, we did the best we could do for the people of California and to protect the public safety. And, you know, that's all I can say. We can't do any more without creating huge problems for the counties, without creating huge problems for this historic realignment that occurred, and without creating huge problems for the public safety, and we just won't do that.
What can happen if the courts don't like your plan?
Again, I can't speak for the court. Well, the court has asked us within 100 days, and now I guess since it's 21 days, so you know, we have about 80-some days, 79 days, I guess, to give the court a list of what are considered low-risk offenders, and so I guess they could potentially take that list and order releases from that list. However, I would remind everybody that low risk does not mean no risk, and we would certainly not want the courts to do that, and my hope is that they wouldn't.
They've already shifted to the county level, most of what you consider low risk, right?
Well, there's still people, when you look at low risk, you see that's the problem. The only remaining, and that's a good point, because the only remaining low risk people that are left in the system are people that you might consider serious and violent offenders. They are low risk to recidivate, maybe, but still they are serious offenders, and that's the group that the court would have to order the release from.
Yet you feel that you have enough low-risk people within that serious offender population to move them into minimum security fire camps?
We're not moving any serious and violent offenders into fire camps.
Would you move, how would you expand the eligibility criteria for fire camps?
We're not expanding the eligibility criteria. What had happened is that when the state changed their classification system a couple of years ago, it resulted in more minimum custody inmates than what we thought we would have. And so when the blueprint was put together, we thought we would have less low custody inmates to go to the fire camp. Today we have more of those low custody inmates, and we're able to maintain it. In fact, today we're supposed to be at 2,500 in the fire camps, and we actually have 3,750 in the fire camps today. But again, these are not serious or violent offenders. Yes?
Actually say that it would ease the criteria to allow serious and violent offenders into the fire camp?
I think the statement that you're referring to there is referring to out years. That if we relied on that going forward, say for 5–10 years, that at some point we may run out of enough of the less serious offenders to keep the fire camps at that level. But within the next few years, we have plenty of the lower security inmates, and so that's not a problem.
Then this gets back to Julie's question. It sounds like a stopgap measure. Because if you're saying the out years, that's not a sustainable thing for the fire. This is a temporary fix, it sounds like, to try to show the court and everybody you're serious.
I think that this is a sustainable fix. I'm not sure when that point comes that we might have to look at other offenders for the fire camps. It's certainly not in the near term. And we believe as we move forward, some of the other things that we have proposed will result in increased releases that will offset any need to reduce the fire camps.
Last question.
Mr. Secretary, in terms of numbers, you said that it falls short by about 2,500. Does that mean that the ultimate release would be about, or reduction would be 7,000 as opposed to 9,500?
You're about right. It would be roughly 7,000 of the 9,300 inmates that we have to find something to do with are dealt with under the plan, which leaves us just about 2,500 inmates short.
Are your 1,600 leased beds in addition to the 1,200 you're already out to bid on?
Yes, that would be in addition to the 1,200 beds, yes. Those 1,200 beds are in CCFs, not in county jails.
And operated, and if you do seek further private in-state facilities, as you said, operated by the state, meaning Union Correctional?
That's correct.
Can I ask you a quick clarification, just because I want to make sure I understand this? the plan that you submitted comes close to what the court has asked you. Are these things you are already going to do? Because someone out there will say, maybe even the inmates' attorneys, why didn't you do this before? Why did the court have to push you to do this last night in a filing? Did you already have all this planned?
No. I think I said, it's not a good plan. The only thing that we had planned was to expand the fire camps when we saw we could do that, and particularly because we have a bad fire season coming up here. And the only other thing that is in the plan that I didn't specifically mention is opening the new health care facility at Stockton, which will give us 1,700 extra beds by July of this year, and then another 1,100 or 1,200 next year.
Why did it take the court threatening contempt to make this happen then?
Because we did not believe that we have to further reduce the population. We believe the population has been reduced sufficiently. We believe that we can manage this population. I've been around and visited over 20 of the prisons. Actually, it's about 27 or 28 of the prisons now. These prisons are running fine at the current capacity level. These prisons are providing a constitutional level of care, and we don't believe we have to do any more. And that's why we have not submitted a plan before this. We're only doing this under court order.
Thanks, everybody.
Thank you.